Well, I'm going to talk to you about employment handbooks, and this is going to be a different sort of presentation. First off, it's going to be fast. And second, I kind of thought that we would just take a step back and look at all of the different agencies and how government agencies press down on the workplace. And the focal point is the employment handbook. The employment handbook is almost always some evidence that a plaintiff attorney is going to submit to support their case. So having an employment handbook that's in touch with what's going on in the world out there is important. So I'm not going to get into any real weedy down into the substance. I'm just going to kind of touch, be like a collage, and here we go. Employment handbooks and alphabet soup. I love all these different acronyms we use in the human resource world. OSHA, NLRB, FMLA, ADA, FLSA, EEOC. You know, you talk to somebody who doesn't do this line of work, they have no idea what we're talking about. Why do you want a handbook anyway? You know what? First off, forget all the legal stuff. It's a great opportunity to communicate to employees, right? You're human resource professionals. Human. So you want to communicate to your people. Communicate. Let them know what your company is about, what the job is about, what kind of compensation and benefits you're going to provide. And oh, by the way, it does serve as a form of legal protection for you in the event you're sued. Because honestly, if you're in business long enough and you grow enough, you're going to be sued. It's just almost a cost of doing business in today's world, unfortunately. So as I indicated, message to employees, whatever kind of specific employment issues are important to you, workplace safety. What do you expect of them? How about you have to show up to work on time? Okay, I know that's a two-part test. Some employees just figure, you know, we'll make it to work. Maybe we're supposed to be there at 8:30, we'll come in at 10. It depends on your business. If you're running a production facility, that's unacceptable. You cannot get product out. And that's a problem in today's world, getting people who are going to show up on time, let alone if they pass a drug screen. And then you're going to talk about compensation, progressive discipline, absence policy. I heard this term a while back, absence management. Have you heard of that before? Absence management? Yeah. So, you spend so much time dealing with people who aren't at work. All of these different policies. FMLA floats into there. Dana's going to talk about that. So, at any rate, I'm now going to start on the agencies and the departments. So, here we go. OSHA, wow, that has been a pretty aggressive agency the last few years. Accident reporting is important to them. OSHA likes to see a company make a statement in their handbook that safety is important, that you care about your people. If you're involved in an accident, I'd just say go ahead and put it in your handbook. Here's how you report it. And this is important. You can put it in your handbook. You can also post the OSHA poster, but you're not going to retaliate against people for reporting an injury or reporting anything that might involve workplace safety. You're just not going to do it, not going to retaliate against them. In fact, you want to encourage them. Now, I'm not going to get too much into detail on this, but as most of you probably know, OSHA has passed a electronic recording and reporting rule. So you're reporting information to the federal government on your recordables, and OSHA wanted to make sure that that information was accurate. So that's why they're very much now focused on employers, their injury reporting policy, and not retaliating against employees. Put this in your handbook, and this is what we always say at Bugby and Conkle: if it's not in writing, it never happened. right? So if you're going to train somebody, you better document it, have them sign it, store it electronically, physically, however you want to do it, but you have to document that you've trained people. Well, this had a lot of chatter on the internet, a lot of seminars about it. A lot of people talked about this post-accident drug testing position that OSHA took. We've done webinars on this, and I actually read the law and the commentary, and I believe, Don, you can correct me if I'm wrong, but I believe it's like 145 pages somewhere in there of small print. And amidst all of this, 152, it's not that far off. Old Navy guy, you know, he's got to get it right. Small print, in the midst of all this, OSHA says, in just a couple of sentences, that automatic post-accident drug testing is discriminatory and discourages people from reporting accidents. They base that on testimony, on experts who went to Washington and gave a bunch of information from a psychological perspective. So that's their policy. Now, OSHA has changed. We're going to have a new director. We have a new administration. We're not quite sure how that's going to pan out over time. What we recommend is, let's go ahead and follow these points right here. You don't do it automatically, but you can almost always find a reason to drug test somebody if you think it's a potential problem. I'm going to move on to the next collage now because we could spend a whole seminar on that. I threw this in. It really sort of random, distracted driving policy. But you know, you probably ought to have that in your handbook now, distracted driving policy. We drive more and more and more for work. I saw somebody 2 days ago when I was, where was I? Mansfield, coming back from Mansfield. And literally they were driving with their knees, texting. And I'm like, oh man, you know, you're not, I mean, you just are gonna, that's a safety hazard. If the employer didn't have a distracted driving policy and that person killed somebody, you know, there could be liability there. Not saying there is, but there could be. So shield yourself from that. Have a distracted driving policy. There is case law that has held employers liable. National Labor Relations Board. I'll bet you wonder what in the world has Carl got the National Labor Relations Board up here for handbooks. I don't know. Somebody put this together. I'm just talking. That's not true. Sorry, Tybo. I didn't mean that. National Labor Relations Board was formed way back, I believe, around the 30s, somewhere in that range, but they dealt almost exclusively for 50 to 60 years with unions, labor issues, labor, unions, labor and management problems, union elections. Recently, in the last 6 or 7 years, the National Labor Relations Board became active in non-union environments. Here's what they're supposed to do. They protect the rights of private sector employees to join together with or without a union to improve wages and working conditions. The acronym for that is WHAT, Wages, Hours, and Terms and Conditions of Employment. Here's what it is. It's a board, 5 members, appointed by the president, confirmed by Congress. They have judges that go around the country, different regional offices. We're in Region 8 with 55 different counties covering that region. This is what they do, but why are they involved in employment handbooks? Case going back to 2004 says this: the mere maintenance of a work rule may violate the law if it has a chilling effect on the employee's right to discuss wages, hours, terms, and conditions of employment. That's known as Section 7 rights. Those words can be interpreted broadly, and they have been by the board the last like I said, 7 or 8 years. This is the case. This is the part of the 3-part test that always gets the activity. Would employees reasonably construe the work rules language to prohibit Section 7 activity? Now that plays into all sorts of different things. The General Counsel issued a memorandum, supposedly for the practitioners in this area. Because I went to a seminar and I heard him talk, and he said, I did this for the practitioners in this area to help clarify our position. Because honestly, some of these decisions coming out of the National Labor Relations Board were insane. Like they weren't even living on Earth, let alone in America. Well, that just actually generated more confusion. These are some of the areas where the board found handbook rules to be unlawful. Just touch on a couple of them. A sexual harassment complaint filed by Joanna. Boeing had a policy, do not discuss any ongoing investigations with other employees except those who are doing the investigation. Well, Joanna was talking, told some other employees, and she was fired for violating that work rule. There are a host of reasons to have confidentiality rules, not the least of which is to protect the person who's filing the complaint. You also want to, I'll call it from a legal perspective, you want to preserve the evidence as purely as possible. When people are chattering and talking about what's going on, stories change. We're going to talk about investigations, but prompt, immediate investigations and documentation can cure this problem. So the board said, you know what, the firing was unlawful. Policy was overbroad. It prevented her from talking about what? Wages, hours, terms and conditions of employment. So a new confidentiality rule has to be created based upon the needs of confidentiality versus the employee's right to discuss about their work. And yes, they've even delved into social media. Boy, social media, you know, we should actually do a session on social media because that's just part of our work anymore. How do you control your brand? How do you control the reputation of your company with social media? We spend a lot of time and a lot of money in today's world on social media. We're a virtual economy practically. When you have employees out there trashing your company, that hurts. It can hurt you as an employer, and also can hurt your company, hurt your brand. Well, what can you do about that? Can you discipline somebody? Can you terminate them? Here's an example. This is a restaurant, Triple Play. Employees were upset. The supervisor or the bookkeeper messed up. I think it was the supervisor. And people owed state taxes. A current employee merely liked this post. Now, this is kind of a nasty post, isn't it? Maybe they should do the owners of Triple Play a favor, buy it from them. Now I owe money, WTF. It's all Ralph's fault. He was the supervisor. He didn't do the paperwork right. It's amazing that a little restaurant, non-union, would know to contact the labor board. And now man, that's pretty astute. A current employee simply liked that post. The management at Triple Play terminated both of those employees. And I'm really skinnying down this case. This has a lot more issues in it. The one employee was charged for posting because she was not loyal enough. That's the reason, anyway, they gave. Another one who simply liked the post was terminated. The board said that these comments were not defamatory or disparaging. Okay? The employer violated their right to concerted activity, to talk about wages and terms and conditions of employment. I can sort of understand that if you buy into the theory that social media is just like the old bulletin board in the lunchroom. If you buy into that theory, then this case makes sense. The difference is the general public was not going in and looking at the lunch board. I mean, you know, that was private within the confines of your facility. Yes? Yes. The question was, the one employee who wrote the post was terminated. The employee who merely liked the post was also terminated. Sort of a complicity conspiracy theory, I guess, that they came up with. And the board said both terminations were unlawful. FMLA, I have one slide on this because Dana Quick is going to talk about the Family Medical Leave Act. And it's simply this: there's good news. Not a whole lot's changed. Okay? Here's the bad news. It doesn't matter. It's still a minefield for you guys. I mean, you have to have it in your handbook. The language, if you probably already have appropriate language in your handbook, but oh my gosh, intermittent leave, protection under this act for employees. Having been a parent of a very disabled child, I understand the necessity for this. But it's clearly being abused today. And HR professionals are spending so much time on 1% of your employees who abuse the FMLA. So outline it in your handbook, identify it, and do the best you can. Call us if you have a problem. At-will employment, you all know at-will. So picture this, okay? Remember Pac-Man, the old Pac-Man games? Well, at-will is the two, like 6 letters, at-will, these little itty-bitty letters. And then Pac-Man is the exception. So yes, we are at-will employment in Ohio. You can terminate somebody for any reason. They can quit for any reason. I'll qualify that for any lawful reason. Except, and then there are millions and millions of exceptions. But you have to have this in your handbook, and it must be prominent. It must be bold to have any sort of authority, at-will employment. Americans with Disabilities Act. And it's kind of fun, though, to think about all the different government agencies and departments that come down on your handbooks. It's just amazing to me when I started putting this together. How am I doing on time? 10 minutes. Okay. Americans with Disabilities Act. You don't want to discriminate against qualified individuals, right? That includes all aspects of employment. Hiring, keeping them, promotion. You don't want to take adverse employment action, so just state that in your handbook. Employees must request reasonable accommodation if necessary. State that in your handbook. Interactive process. Everybody knows about the interactive process, right? Somebody comes in, says, I got a hitch in my get-along, and my right leg is 4 inches shorter than my left leg, and I cannot do this job as it's currently designed. Then you begin the interactive process. You talk to the individual, document all of the discussions. If it's reasonable, make an accommodation for them. It doesn't have to be the best accommodation, but you want to lay this out in your handbook. Just identify it. I highlighted this, well actually somebody in our staff highlighted this on the bottom. Train frontline supervisors to recognize requests for accommodation. It's not just in the ADA. Your frontline supervisors make or break your company many times. We always see these cases on the back end. Usually that old Fram oil filter. I've heard Tybo use this example many times. You can pay us now, or you can pay us more later. But on the front end, you can solve problems. And the biggest and best way to solve the problem is to train your supervisors, the people who are there. From an evidentiary perspective, an adjudicatory agency, could be a judge, could be a jury, likes the evidence that is pertaining to the event, timely. Frontline supervisors are there. They're the ones who see these people. They're the ones usually who interact with them first. That's your first line. So train them regularly and document the training on all aspects of employment law, not just the disability law. Fair Labor Standards Act. Tybo touched on this. You know, there was this big decision to change the overtime law and basically increased the amount of earnings that an individual could earn and still get overtime. So I know we had clients that caused a lot of problems with. Now that is non-existent or defunct. We don't really know where it is. Basically, the theory is that it's not the earnings that are the determinative factor, but it is what kind of work does this person do? Does this person exercise individual decision-making capacity? I put this in the handbook discussion because take this opportunity to define your work week. Just simply, our work week starts on Monday and goes through Sunday. You can start it on Sunday and run it through Saturday. However you want to do it, identify your work week. Eventually, we're going to get beyond the industrial age, I think. We're moving into the information age. But the concept of 24-hour work periods, a work week, is still existent. Can you designate a work week to reduce overtime? Don't look ahead. Does anybody think you can? Does anybody think you cannot? Yes. Mark thinks you can. Yes. Any contrary opinion? It's okay, you can talk. I'm an easy guy. I'm kind of fun. I'm not going to pick on you. Yep, you can do whatever you want. You design your work week, okay? If that means that they don't get enough overtime as much as they used to, that's fine. That's not contrary to law. Court specifically said an employer's efforts to reduce payroll expense are not contrary to the Fair Labor Standard Act. So define your work week. 5 minutes, basically. 2 minutes. You're failing your job. I didn't see the sign. Should be walking back there. EEOC, Ohio Civil Rights. You're pretty familiar with this, so I am going to go through this quickly. Affirmatively state that you do not discriminate based on these protected categories. In any area of employment, that includes advertising for jobs, recruitment, applications, hiring, background checks, et cetera, et cetera. Now, one thing I'm going to bring out now before I forget, you will note, I'm not discussing progressive discipline in this handbook discussion. A little unusual, but we're going to touch on that in our interactive session here today. These are 2 protected classes. These are issues that you come up against when you're dealing with race and color. Background checks, discrimination investigation, equivalent discipline, inherent biases. Religion, make sure that there is some notice that they need accommodation. You do the interactive process. Mandatory attendance, we run into that sometimes. A Orthodox Jew does not work on the Sabbath. Some Christian religions don't work on their Sabbath. So that is something that you're going to run into. We are going to cover some of the modifications and gender identification issues. Investigate, investigate, investigate. And that's what we're going to talk about this afternoon. Or, oh, yeah, we're in the morning now, aren't we? So it's going to be after break. And I just went through a 30-minute presentation pretty quickly. I think are we back on time now? Great. I'm going to be around all morning. We have Tybo and Dana here as well, so if you have any other questions, please feel free to talk to us.